have signed an arraignment, and there's not an opportunity to contact defense counsel to clear the dates with their calendar, and that's not necessarily the nature of the case. However, I've been previously scheduled for quite some time, and I attached the assignment notices for both county court and juvenile court cases, and I understand that the victim's position. However, the defendant has a right to have competent counsel, and if the court will not continue, the court will have to simply appoint new counsel, and for counsel to be able to get prepared in about 10 days is probably not going to happen. I don't think, if the case has not been continued before, it's not unreasonable to have a continuance.
When's the first day of school?
Hold on a second. Let me make sure I'm right about this.
I think we scheduled it tentatively for August 15th.
Yes, that's true. Have you got a time waiver from your client, Ms. Hapner?
I have not. I'll be going out tomorrow to get that covered.
All right, Mr. Taylor, under the law, there's a 90-day time which a person must be brought to trial after their arrest. And in this case, I believe that this arrest occurred, let's see, was it May the 3rd that he was arrested? This case was not bound over, right? This is a direct indictment? Yeah, May the...
Yes, it was. Direct indictment, I'm sorry.
All right, and so that put the speedy trial deadline then as July 31st. So the trial was set a week prior to that. Now, under the law, if there are certain things that do extend that, and I haven't calculated that, but I know there was a demand for discovery on the 17th, and it looks like that was complied with on the 24th, so that would extend it a week. And then there was a request for discovery by the state, and I don't know, do you know when that was, compliance was filed, Ms. Hapner, or have you been able to do that yet? I don't see it here.
Ms. Hapner?
Yeah, Ms. Hapner, do you know if you filed your compliance yet with discovery? Looks like she's
I think
frozen.
she must be frozen.
She's frozen. I can hear you. Can you hear me?
I can hear you fine.
Yeah. Everybody else is good. Ms. Hapner, would you text her and tell her to log back in, log out, log back in? Mr. Taylor, you were arrested on the 3rd of May, is that correct?
Second.
Second? Okay.
Yeah.
So, all right. So the speedy trial date would still be July 31st, because that'd be 90 days. All right, there you're back, Ms. Hapner. We lost you there for a minute. Can you hear me okay? Ms. Hapner, can you hear me?
I keep getting bounced off.
You're here. You're on now. Yeah, we lost you there for a minute. Didn't lose anybody else. I don't. It's been a weak signal or some kind of a
Bouncing me off.
gremlin. So, well, I wasn't bouncing you off. It was, those computer gremlins.
I didn't mean you accept that.
Yeah. Okay.
It is.
All right. Anyway, I was telling Mr. I was going through the discovery. The question was, have you filed your compliance with discovery yet?
No, I think you gave me till this Friday to do
Okay,
that.
that's what I thought. Okay.
And
All right. And so that actually, I was explaining to Mr. Taylor, that would extend the 90 days as well. And the question then, Mr. Taylor, is that if the court also, as an additional grounds to extend the speedy trial, if you agree to that, and the trial's upon the motion of the defendant, which it is, because Ms. Hapner has these conflicts, then that would continue as well. So the proposed new trial date would be August the 15th. So are you in agreement with Mr. Taylor to have this case continued? Because as Ms. Hapner said, if I had to try to find another attorney, I'm not going to find an attorney in this country that would be able to come in on July, assuming I could get somebody tomorrow, July the 12th, and be ready in 12 days for a trial. So are you in agreement with the matter being continued, Mr. Taylor?
Yes.
All right, so you're agreeing to waive your speedy trial time if it hasn't already been waived, which I think it still has. Okay. All right. Well, the court's going to grant the continuance. The matter was set, because of the speedy trial time fairly quickly. These are three very serious charges, and a continuance of a month or less than a month of 3 weeks is not unreasonable. So the matter will be tried on August the 15th at 8 a.m.
Thank you, Your Honor.
And then, as you said, your discovery and any pretrial motions are due by Friday.
Yep.
All right. Thank you.
Thank you.
So, next case will be Reese Fist and Joey Ray Dixon Jr. Case number 23 CR 77 for Fist, and I forget what the case number is for Mr. Dixon. Mr. Dixon's attorney this hearing is being conducted by Zoom. Mr. Dixon's attorney is appearing by Zoom, Mr. Wagner, and then Ms. Fist's attorney is Ms. Hapner, or Ms. Witt, I'm sorry. And representing the state is Prosecutor Collins. And Mr. Wagner did indicate his client is driving and is not able to log in, and so I have waived his presence for this hearing. This is a motion for continuance, and on the court's motion for this case because of the fact that there's been a suggestion by the defense, and I believe the state is in agreement that there is a Bruton problem if we try to try these cases together. Is that correct, Ms. Collins?
Well, there could be if we choose to use the statement of one of the co-defendants. There have been a couple of developments in this case. Ironically, the state is going to agree to the continuance. I believe both defense attorneys want the continuances in this. But just this afternoon during the lunch hour, Ms. Witt asked us about a stipulated polygraph, and we've already got that set up. And we have the paperwork ready for her to sign and go over to her client, and that it's already been scheduled for July 20th.
Okay.
And that may take care of the issue of all issues.
All right. I've neglected to ask, have the representative of the alleged victims been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, and they do not object to the continuance.
Okay. All right. Well, I think we had a tentative date for this one, but I can't remember what it was. So right now, we're going to need to set, I guess what I do is I set one date for a joint trial, and then the state would have to notify 2 weeks in advance whether or not they would attempt to use a statement of one against the other that would necessitate a severance for trial, so we'll have a backup date as well.
August 17th and 18th is your current date, Your Honor.
Right. So, the court will grant the continuance until August the 17th at 8 a.m. Now, as far as a polygraph, as soon as you can get that done, Ms. assuming that it does get signed, we'll need to have a hearing. We can do that by Zoom to put on the record the stipulation of the polygraph. And you are in agreement with this, Ms. Witt, to having the matter continued?
Yes, Your Honor.
All right. And the current trial date is, what, counsel, 24th?
No, it's the 27th.
27th? Okay. So I'll continue the trial on both cases to August 17th, 2023. And then we'll have a backup date in the event that both cases go to trial and there needs to be a severance. And I would set that for a lot of trial dates coming up. Set that for August the 31st. Also at 8 a.m. We'll set another pretrial. I don't know if I set one in the other case, Mr. Wagner, do you recall?
I think we're just set for the 17th unless.
Yeah,
things change.
and I believe you actually filed a motion in a written motion, did you not?
I did.
Yeah, okay. And I don't know, if we didn't set a pretrial, I want to go ahead and get another pretrial set. Let's say,
May I inquire with the court, Your Honor?
yes,
So, I know there's a lot of moving parts right now, but maybe I misunderstood the court, but if I got it correctly, should both cases go to trial and we have to sever, I guess just so I can be fully prepared, would one of us take the 17th and one of us the 31st?
well, I think that'd be up to the state to select who goes first. And so, state will notify the court at least 2 weeks prior if trials need to be severed and which case will be continued. And pretrial will be on August the 2nd at 1 p.m. So that's going to be the 2 weeks.
Yes, sir.
All right. Thank you. Okay, this is case number 23 CR 109, State of Ohio versus Sally Michelle McKenzie. Ms. McKenzie is appearing from the jail by Zoom. Her attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office is Prosecutor Collins. Defendant is charged with aggravated trafficking and aggravated possession of methamphetamine. This is a first pretrial, and the final pretrial is set for August the 2nd, and then trial set for August 28th. I don't see any discovery requests here. Have you filed your discovery request, Ms. Witt?
She filed it on she filed it on June 16th, and we've already complied.
Oh, really?
Yeah. And she
Oh, here it
filed
is. Okay. Yeah, here it is. It was with the financial disclosure form. Okay, I see that. All right. Do you anticipate any pretrial motions, Ms. Witt?
No, none at this time.
All right. Yours will be due by final pretrial, and any discovery will be due by final pretrial, and if there are any pretrial motions, they'll be due by then. Has there been a written plea offer provided?
Yes, Your Honor.
Is your client aware of that, Ms. Witt?
Not yet. I will go out to see her.
All right. All right. Are there any other matters that need to be discussed at this time?
No, Your Honor. No, Your Honor.
All right. Thank you.
Yes, sir.
All right, this is case number 23 CR 88, State of Ohio versus Robert Dwayne Throckmorton Jr. And you're Robert Dwayne Throckmorton Jr. appearing there from the jail, from the probation department. Actually, it says tab at the screen. Are you at
First Capital Recovery.
First Capital Recovery? Okay. All right. Now, Mr. Throckmorton's attorney is Danielle Witt, and she's appearing from her office. Appearing from the prosecutor's office, Prosecutor Collins. Matter is set for a plea hearing. Ms. Witt, do you and your client both agree to waive the defendant's physical presence in the courtroom and agree for this matter to be conducted by Zoom?
Yes, we do.
You're all right with that, Mr. Throckmorton, doing it from where you're at instead of coming back here?
Yes, sir.
All right, now, if during this hearing you need to talk with your attorney about anything, just let me know, and I can put you and her into a breakout room where the two of you can talk privately, and we'll ask your caseworker there to step out of the office so you can do that confidentially and have any questions answered, okay?
Yeah.
All right.
Yes, sir.
Now, Mr. Throckmorton is charged with aggravated possession of methamphetamine, a fifth-degree felony. I have here a proposed plea of guilty form, which looks like it was faxed here. Well, I don't know, a couple faxes. Looks like it was faxed somewhere on 7/10/23 at 23:37, and then today at the bottom on the other side from Hapner Law Office on 7/11/2023. And I assume that must have been the prosecutor's office, or the prosecutor's office brought this over to us. Is that correct? Or okay. So I'm going to hold that up to the screen just so you can take a look at it and make sure you recognize that form. There, Mr. Throckmorton, with your name, plea of guilty, and your charge.
Yes, sir, I do.
All right, and on page 3, there is a sentence about a quarter way down the page. It reads, "I enter this plea voluntarily," and right below that there's a signature. Looks like Robert Throckmorton Jr. And is that your signature there on that page?
Yes, sir.
And did you sign this on the 10th of July? That would have been yesterday? Pardon me?
Signed, yes.
Okay. And before you signed this, had you been discussing the matter with your attorney about what the plea agreement might be?
Yes, sir, I did.
And did you read this all over before you signed it?
Yes, sir.
And do you feel you had enough time to fully consider the matter before you make this decision?
Yes, sir, I do.
And were you pressured or rushed in any way into doing this?
No.
Now, did you sign this agreement to plead guilty voluntarily?
Yes.
And again, you understood it was an agreement to plead guilty when you signed it?
Yes.
All right. And did this agreement contain what you understood would be the plea agreement when you talked with your attorney?
Yes, I did.
All right, now the agreement states you're going to plead guilty on page 1 to the charge of the indictment of aggravated possession of methamphetamine, a fifth-degree felony under 2925.11 of the revised code. Further states that you understand maximum penalty for that could be 12 months in prison, the minimum could be 6. If there's a prison term, there's a fine possible of up to $2,500 and a possible license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, if you're convicted of this offense and should you be sentenced to prison, then upon completion of the prison term, the law provides that it is possible the adult parole authority may put you under what's called post-release control supervision for a period of up to 2 years, which means that you'll be supervised on the terms they set by a parole officer, and if during that period of time they determine that you have failed to comply, they can return you to prison, make you serve an additional period, in this case of up to half of whatever prison term was ordered for one or more violations. But if you commit a new felony, then in addition to whatever sentence the judge in that new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time was left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Right now, under the law, I'm not required to sentence you to prison for this offense. I can grant you what's called community control instead, and that means that you'd be put under supervision of the probation department under terms set by the court for a period of up to 5 years. If during that period of time probation felt you were non-compliant, they would file written notice of that with the court. There would be a hearing. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to the 12 months and fine you $2,500. You understand that?
Yes, sir.
All right, the charge against you, Mr. Throckmorton, alleges that on or about January 7, 2023 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine in violation of Section 2925.11. So that's the charge, 5th-degree felony with the penalty I just explained. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they led you did it?
Yes, sir, I did.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues of the case, the possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty here today?
No.
Now, on page 2, there are a couple lines that I'll read as follows. They're bold and underlined on page 2. And they read, defendant shall enter a plea of guilty to the indictment, state and defense jointly recommend community control, and defendant be referred to drug court. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentencing is up to the judge. So even though there's an agreement that you should receive community control and be considered for drug court, that's not binding on the court. Once I've heard all the information presented, if I decide that's not the correct sentence, I could sentence you to a prison term of up to 12 months. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
No.
All right, now you have certain constitutional rights you must understand before you can be considered for entering a plea of guilty. First of all, you have a right to have an attorney, and Ms. Witt was appointed to represent you, not simply to work the case out, but to provide any defense that might be available to you under the law that you would wish her to provide. So, if you decide that you do not want to do this, that you would rather defend against the charge, she'll continue to represent you, including a trial, if that is what you want. Do you understand that?
Yes, sir.
All right, now under the law, you have a right to have a trial by jury in this case. And what that means is that 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date. Once they are selected, the evidence would be presented, and then the judge would instruct them on the law. And that judge, or that jury then, would have to decide by unanimous verdict. It means all 12 of them would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, then you can waive in writing, which means to give up your right to have a jury trial, and in that case you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. What that means is that if you have witnesses you're uncertain are going to come in voluntarily, your request, the court issues a court order called a subpoena, which forces those people to come to court, be named, that are named in the subpoena, to come to court to testify on your behalf if you want them to, even though they don't want to be here. which is the same way the state's witnesses are forced to come to court to testify against you. You understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witness against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, meaning you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to talk about it, with one exception. If there's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Throckmorton, you have a presumption of innocence, which means you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So the burden of proof isn't on you to try to prove you're not guilty. The burden of proof is upon the state to prove that you are. In fact, under the law, the state doesn't have to present any evidence at all. I'm sorry, you do not have to present any evidence at all at trial. You may, but you're not required to. But whether you present any evidence in your own defense or not, the burden of proof will remain upon the state to present evidence that convinces the jury or the judge, depending upon which trial you elected to have, of your guilt by proof beyond a reasonable doubt on every essential element of the offense charged. And that's the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you pled not guilty in this case to this charge, which denied the allegation in the indictment, denied you committed any crime, and it exercised and invoked all the rights that I've just described. If you change that plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that you committed the crime, and that plea waives, gives up all the rights that I just explained for you today, except your right to have an attorney. If you you always have a right to have an attorney, no matter what your plea is. But if you plead guilty, you will waive or give up your right to a jury or court trial. You would waive or give up your right to cross-examine witnesses in open court through your attorney. You would waive or give up your right to use the power of the court to compel or subpoena witnesses to come to court to testify on your behalf, the same as the state. You would waive or give up your privilege against self-incrimination because you're the one saying you're guilty. That's what's used to find you guilty. You're waiving or giving up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. Subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence or under certain circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
Are you a U.S. citizen, Mr. Throckmorton?
Yes.
Now, you have any questions about the charge or the possible penalty?
No, sir.
You understand them?
Yes.
Have any questions about the plea agreement?
No.
You understand it?
Yes.
Again, you understand the recommendation on sentencing is not up to the parties, that's up to the court.
Yes.
Do you have any questions about the constitutional rights I've explained?
No.
You understand that?
Yes.
Have any questions about the plea of guilty, what will happen to that, or what it means if you enter that plea here today?
No.
You understand that?
Yes.
Now, is there anything you need to speak to your attorney about before we go any further?
No, sir. I've already spoken with her this morning.
Okay. You have any questions about anything that I've gone over with you today?
No, sir.
Then is it your decision to withdraw your not guilty plea and enter a plea of guilty pursuant to the terms of the plea agreement that we've just discussed?
Yes, sir.
Then as to the charge, which alleges that on or about January 7, 2023 in Huntington County, Ohio, that you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, a 5th-degree felony carrying a possible prison term between 6 to 12 months, fine to $2,500, and a possible life suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. Court finds on this day in open court, defendant was advised of all his constitutional rights, made no intelligent voluntary waiver of the same pursuant to Criminal Rule 11. Please accept and order filed. Defendant finds that the defendant has entered a plea of guilty and therefore convicts the defendant of this offense. The court will order the matter be referred to the probation department for a pretrial report, which will include an assessment for substance use disorder and or mental health. The case is referred to the drug court docket, and sentencing will be August the 24th at 1 p.m. Now, you'll need to meet with either Ms. Sturgill or Ms. Davis because people that go into drug court have to want to do that. That's not something court orders them to do because it is much more involved and stricter and tougher than regular community control, but it appears from the data that it is much more successful than regular probation in keeping people from relapsing and committing new crime. So that'll be something you'll need to speak with them about. They'll make a determination of whether you meet the clinical criteria, and then if that's something you want to do at the sentencing hearing, the court will inquire and then make that decision. All right, is there anything, bond is continued as well, so which means you'll need to remain in treatment pending the sentencing. Anything further from counsel?
No, Your Honor.
All right, thank you.